A court just ruled that Aboriginal title cannot take back private land, and that decision may help determine the future of property rights in Canada. Today I'm going to be breaking down a landmark ruling from the New Brunswick Court of Appeal, a constitutional fight over Aboriginal title that spans over the western half of the entire province. This is the latest chapter in one of the most consequential legal questions in the country. What happens to private land when Aboriginal title is affirmed by the courts? Before I get into it, make sure you hit that subscribe button below so you're staying up to date on what's happening in our real estate market. So let's get into it. I'm going to be focusing on the case J.D. Irving Limited versus Wolastoqey Nation. And this deep dive is really about the court's attempt to draw a hard line on whether court-declared Aboriginal title can extinguish private property rights. At the center of this decision, which came on December 11th of this year, is a really interesting paradox in the court's reasoning. On one hand, the court found that claims against massive industrial landholders were necessary. On the other hand, it said that it was plain and obvious that the claim to actually take private land back had no chance of success at trial. How the court gets to both of these conclusions at the same time is the core of this case. To understand the scale of what we're talking about, the claim covers the entire St. John River watershed. In the court documents, Schedule A lists over 280,000 parcels of land. More than 250,000 of those parcels are privately owned by individuals or corporations. The specific appellants in this appeal are large industrial players J.D. Irving, Acadian Timber, and H.J. Crabbe & Sons. Their lands are listed separately in Schedule B, and their involvement is what turned this into a direct head-to-head property rights dispute. On the other side of this case are the respondents, 6 Wolastoqey nations acting together on behalf of the Wolastoqey Nation as a whole. When the claim was first filed back in 2021, they were seeking 3 main things. First, a constitutional declaration of Aboriginal title over their traditional territory. Second, and this is the critical part, the return of some of that land, specifically the parcels held by the industrial defendants. And third, compensation from the governments of Canada and New Brunswick for historical wrongs. And that immediately raises a key question. Aboriginal title claims are constitutional claims against the Crown. So why were these private companies sued directly? The answer is that this case was never just about the money. The Wolastoqey nations were seeking repossession, and if you want the land back, you have to challenge the legal basis of the current owner's title. To do that, they went after some very direct remedies. One was ejectment, which is exactly what it sounds like, physically removing the companies from the land. To get there, they relied on a very powerful legal tool known as sire fascius. In plain English, it's like a legal reset button. You're asking the court to declare that the original Crown grant, the deed first issued by the government, was fundamentally flawed. If that grant is invalid, the current title collapses. The land reverts to the Crown, and it can then be transferred back to the nation. That's why J.D. Irving and these other companies had to be named as defendants. The case first went before the Court of the King's Bench, and that approach was initially shut down. The motions judge ruled that the industrial defendants were the wrong parties. Her reasoning was that the constitutional dispute was really between the Wolastoqey and the Crown, and that there was no direct legal relationship with the private companies. So she removed the companies from the lawsuit. At first glance, that looked like a win for the homeowners. But this is where the lower court made a critical mistake. Even after removing the companies as defendants, the judge still allowed the Wolastoqey Nation to continue pursuing a declaration of Aboriginal title over the company's privately owned land, which is bizarre. In other words, the landowners were told that they weren't needed in the lawsuit, but the court might still decide the legal fate of the land that they own. That created legal chaos. And more importantly, it violated a basic rule of fairness. On appeal, Justice Drapeau focused his analysis on procedural fairness, specifically the principle known as audi alteram partem, which is the right to be heard. If a court decision could negatively affect your rights, especially your property rights, you have to be a party to the case. You have to be allowed to defend yourself. And the court made this explicit. The property rights of these companies are no different than those of ordinary homeowners. this case isn't just about corporate timberlands. The precedent could affect every person who owns property within the area of the claim. But that still left the bigger question. Even if the companies had a right to be heard, could the claim to actually take their land still possibly succeed? This is where we get to the absolute heart of the ruling. The Court of Appeal drew a crucial line between a finding of Aboriginal title and a judicial declaration of Aboriginal title. A finding is historical and factual. The court looks at evidence of exclusive occupation prior to Crown sovereignty and can conclude that Aboriginal title existed on that land. The Wolastoqey Nation is fully entitled to seek that kind of finding, even over privately owned land, because that finding can be used to support a claim for damages and compensation against the Crown. It's the evidence needed to argue that the Crown was wrong to grant the lands in the first place. But a finding alone does not burden private title. The deed stays intact. A judicial declaration, on the other hand, is the remedy. It confers the full bundle of ownership rights: possession, use, economic benefit, and control. Those are the same rights that come with fee simple ownership. Justice Drapeau was unequivocal. He said he was unable to see how those rights could coexist with the very same rights vested in fee simple owners. It's one or the other, and this is where the court draws a very clear line. Granting declarations of Aboriginal title over private land, including ordinary homes, would, in the court's words, sound the death knell of reconciliation with non-Aboriginal Canadians. Instead, the court said remedial justice favors compensation from the Crown, not dispossession of private homeowners. Private land stays private. The remedy is money, not taking land back. There's also an important piece of context here that helps explain why this decision looks the way it does. New Brunswick does not have anything like British Columbia's DRIPA. This also means that UNDRIP has not been incorporated into provincial law in New Brunswick. And in my last video, I go over DRIPA and UNDRIP in detail. So this court was not having to ask whether its remedies needed to be made consistent with UNDRIP. It was operating strictly within the traditional Canadian constitutional framework, Section 35, Common Law Property Rights, and the limits of judicial power, which is a sharp contrast from British Columbia. In BC, DRIPA was passed in 2019 under the NDP, and it changed the legal environment by requiring provincial laws to be aligned with UNDRIP over time. It's not wrong to say that without DRIPA, the Cowichan case may have been analyzed much more like the New Brunswick case, with courts drawing a harder line around fee simple ownership and steering reconciliation towards compensation rather than repossession. Now, that doesn't mean that DRIPA 100% dictated the outcome of the Cowichan case. The courts are still independent, but it clearly shaped the legal questions the judge was required to engage with. So where does that leave things now? For private property owners in New Brunswick, the immediate threat is gone. The Court of Appeal struck the claim for declarations of Aboriginal title over private land. Repossession through this litigation is off the table. But the lawsuit is far from over. It continues on two fronts. First, the Wolastoqey Nation is still seeking declaration of Aboriginal title over Crown land, which still involves tens of thousands of parcels. Second, they can still pursue findings of Aboriginal title over private land and use those findings to support a massive compensation claim against the Crown. It's also very important to note that the Wolastoqey Nations have already said that they intend to seek leave to appeal this decision to the Supreme Court of Canada. This is now a national issue. New Brunswick has built a firewall around private property. British Columbia has not. Two senior courts, two fundamentally different legal philosophies. And now the Supreme Court of Canada may be asked to answer that question head on. Can reconciliation under Canadian law ever justify court-ordered dispossession of private landowners? The stability of property rights across the entire country may hinge on how that question is resolved. This debate is far from over. So if you're wondering how future land claims could affect your property, book a one-on-one call with me using the Calendly link below and we can go over it together.